Mr. Hicks, you have 15 minutes for your argument. Did you want to reserve some of that time for rebuttal?
I'd like to reserve 4 minutes, please.
4 minutes? Very good. And as before, you may assume we've read the briefs and are prepared to discuss the case in greater detail, more of a conversation. So
Okay.
we're
Thank
ready
you,
if you
Your
are.
Honor. This case, I think, is an important one, and it really relates to whether, when the government creates a system for creating and distributing its approved messages, do citizens have a right to know, when part of that system is a database and a mailing system for mailing it, who exactly is receiving those messages? Who exactly is getting those things? This morning when I woke up, I thought I better make some. I'm not a lawyer, I'm pro se. I thought I better make some notes on each of the cases that has been cited by the township. And I realized something about them just this morning. Every one of them is about people trying to find out information about people, about kids that went to a swimming pool, about jurors in a jury pool, about public employees and their home addresses. I'm not trying to do that. I'm trying to find out, where does the government send, in a system that it built, its approved messages? Does it send them to all people? Does it send them to residents only, to business owners, only Republican voters, only Republican primary voters? How does it curate that list? When somebody signs up, do they sometimes get quashed, et cetera? I'm not trying to find out.
Let me go to Dispatch v. Johnson, which was the employee question.
Yes.
As I read the Supreme Court's decision, it doesn't say they're not public records because they're employees' personal information. It only goes as far as saying that kind of a list maintained by the government is not related to the government's principal functions. So in this case, Union Township, I assume they've got a police department, a fire department, they got a road maintenance, they dig ditches, they take care of things in the community. They don't mail things to people as part of their function. This list that they maintain to mail a newsletter, I think it is, to the community is more of one of attempting to be transparent on what they are doing rather than trying to conceal who it is they're sending to. I don't know if you got one as one of the newsletters in the mail or not.
Here's one that just came out.
Is that yours, the address to you? So you know that at least you're on that list. So if the Supreme Court didn't take that next step and say, and in this case, this list is private and not a public record because it contains employees' personal addresses, if they kept it at that limitation, that because it doesn't serve the government purpose or function, then how do we go around that? Because we're not the Supreme Court.
There are very different situations of a system where in today's world the government can target its messaging, craft its messaging, and hit specific audiences, only Republicans, only Democrats. That case, Your Honor, I'm sure you're aware, was specifically about public employee addresses that are used for things like sending out their W-2s. You'll also note that in that case it said that had the person been trying to, if there had been a requirement that the employees had to live in the governmental entity, then they would have been public records. It also specifically says in that case that it's to be applied narrowly, specifically to public employee records within that case. So I appreciate the question, but I think it's a good example of how a case is being used in a broad way in a world today where there can be digital curation of lists, and this is specific to government-approved messages. This is a First Amendment type issue. How can I know that my neighbor's on the list, not on the list? How can people respond to messages? How do they know who's getting what message?
You know, the premise with which you began your argument, Mr. Hicks, about how you're not requesting information about people, I can see how that would apply to the mailing list for the newsletters that the township has their direct mail vendor send out. But the other mailing list of the people that have gone online and requested an electronic copy of it, it doesn't apply to that, does it? I mean, the only reason to have that would be to identify those people, because the township hasn't decided who to send those to. The township sends those to people who have requested them. You agree, disagree? Am I missing something?
I disagree, because I think there is likely a curation process that's going on behind that list. So there's a system built and a database created where people opt in or opt out that feeds into a mailing system. I'd also ask the court to think, again, I think there's First Amendment considerations here. If I, for example, as a quote-unquote, they would say, self-appointed watchdog, can't tell who's getting what messages, how do citizens then respond to those messages if they chose to respond to them? So, for example, the right of access to government, to be able to know what government's doing, is fundamental to the First Amendment to be able to redress grievances. So I think that both lists, first off, the lists contain nothing more than either an address or an email address. And I think in both cases,
So there's no name?
in the opt-in one, they can type in a name, it's not required. But on the newsletters themselves, it just says "our friend at"
Okay.
on it. So it doesn't have, but for example, I don't know if these go to only Republicans, only Democrats, only businesses, only residents, only some residents. The same with the curation of the email list. I don't know if people, when they sign up to it, that if I analyze it, I find, well, this is funny, Democrat voters get taken off this even when they sign up. That's a fundamental, one of the things brought up is, what's in furtherance of the Public Records Act? What's in furtherance of the Public Records Act is things that allow for citizens to require accountability to government. And when citizens can't know where government is curating and sending messages to, how can they do that? As an example, just recently, I found that our police department in our township actually was curating access to its social media for who could see their messages online. And they weren't messages they were just messages about people they're looking for and so on and so forth. So this is a really important case. And I apologize for maybe my being a little disheveled the way I'm coming at it here. But this is about when government, with now the modern tools it has, can target, and to make sure that that's not happening. And these other cases, you know, the one you mentioned that involves public employee records, there's no purpose in that to monitor the performance of government, but knowing where government approved messages and a system that's been built by government are going is really important to the process. So I actually think if you look at the case law, there's almost no guiding case law on a case like this. All of the cases involved where somebody's trying to get information on some special demographic group, public employees in their home addresses, people who were on a jury pool, people that were using a public pool, those kind of things. This is about more broadly when the government puts a system whose sole purpose is to both create and disseminate government-approved messages. Do citizens have an ability to monitor? Is the one part of that is who are those messages going to? I think it's a very important case, and that's why I appealed it. By the way, this is my first and hopefully my last time coming before you guys. So, but I appreciate the question. So I think ultimately I said that there were 5 errors. There was one error, the decision, and there were 5 reasons. One is, I pointed out, is this is not part of any statutory exception. If the legislature wanted to have an exception, they could have an exception. Access is essential to monitoring government. This isn't trying to track down public employees where they live. This is about where the government-approved messages that have been curated in a system by the government get disseminated. I think the cases are off point that have been cited by the township. They're all cases that involve ultimately trying to find out about specific little groups of individuals, not to monitor the government's performance and where it's sending its messages. They are not administrative in nature. It's really a stretch, I think, to say the records are only administrative in nature when it's a database system for which people were hired to build to keep track of these records, and outside vendors were hired. Access is completely consistent with the intent of the Open Records Law for people to be able to monitor government and people to know what their government is doing and who is getting those messages.
Was there any evidence submitted in this case that would indicate that the township had any say as to what type of database or as far as the mailing list was concerned as to who this newsletter would go to?
Well, there was a person that was hired specifically to run the newsletter that did it, I think, for 10 years maybe. It's in the briefs, tenor. And yes, they worked with the mail vendor. There's actually 2 affidavits, one by the current administrator and one by the person that ran the program, and they actually conflict. One of them, I can't remember which one of them says it only went to residents, one of them says it went to residents and businesses. But that work was done curating that list with the township involved with an outside vendor.
Well, you're still not answering my question.
Okay.
What evidence from either an employee of the township or the vendor himself that the township had input outside of the vendor as to who was going to receive this mailing list?
I think that's in the affidavit of the person that ran the newsletter program, that they worked with the vendor to come up with it, and they were targeting certain people. The current administrator says it was actually targeting different people. That distinction was not the bigger types of examples I make, but on business versus residential. But I think you'll find that in the actual affidavit by the person that ran the program. It was also part of their job description to work with the vendor to come up with those lists.
Did the vendor intervene and argue that it was a proprietary list, not subject to disclosure?
I don't think that vendor's ever been engaged by the township in relation to my records request.
Yes.
I don't know that the vendor's ever been engaged, and I certainly didn't go directly to the vendor and ask them for the list.
'Cause I think most print shops can do those lists, and they can split them out, as you say, to specific streets or demographics. There's a lot of sorting
Right.
abilities they have.
Well, and the danger is that today's world, they could hit a button and sort, let's not send it to Democrats. Let's not send it to this group. Let's not. So I think that's why being able to monitor where these kind of things are going is a different kind of case than the ones that have been cited. And I think it's kind of a new case, a new precedent type case.
All right, you still have 4 minutes, unless there's further questions presently.
No.
All right. Mr. Conover.
Thank you. Good morning, Your Honors. Presiding Judge Powell, and may it please the Court. Brody Conover on behalf of Union Township. I want to start, Mr. Hicks and I were talking before court. This is the first 2743.75 appeal to the 12th jurisdiction, which we were both kind of surprised by.
Well, they took the Court of Claims cases and gave them to the local.
Yeah.
They all used to go through
Yep,
the
totally
10th, so
understand.
we're happy to get it.
Yeah, kind of. But I did just want to clarify, I wouldn't typically do this, but the standard of review on a case like this, a public access case coming from the Court of Claims, the Supreme Court in Walsh-Huggins v. Jefferson County in 2020 basically said that this is a standard public records mandamus case. The standard is clear and convincing evidence. The burden is on the requester in this case to show that these are public records and that they should be provided to him in response to the public records request that he submitted. And then finally, on mixed questions of law and fact, the court obviously would review the legal conclusions de novo, but the factual conclusions by the special master and then the Court of Claims in this case are only subject to review when there's been clear error. I don't think there's ever been any sort of argument by Mr. Hicks that there was any sort of clear error on the part of the special master or the Court of Claims. So I say that only to say that the evidence before the court was, the special master discussed it in his opinion primarily on pages 4 and 5, and the factual conclusions he reached, I think in this case, are important. One, that there was really no dispute that there was this system. Two, that the list was created, that the mailing list was created, curated, and handled by a third-party printer, vendor, direct mail company. The email list was where someone could just sign up. As Mr. Hicks says, they can submit their name, they don't have to. They could put in, Thomas Jefferson, whatever sort of, public watchdog email address they would like to, so the township has no idea who they might be. And then also that the lists were kept for purely administrative convenience. That was a factual conclusion reached by the Court of Claims that has not been appealed, I guess, in this case.
What does administrative convenience mean?
Yeah, so I think if you look at the Supreme Court cases and the Court of, there's obviously now in the last 7 years been a significant amount of case law from the Court of Claims on public records issues. I think you find that it's, I don't want to be, there's not a clean definition that said this is administrative convenience, but I think it's something that just doesn't really impact the decisions, the policies of the public office. So 149, sorry.
If the township is sending out a newsletter that's telling the community, the business community, the residential community, whoever, what they're doing, there is an argument that they're fishing for information on what they should be doing or could be doing better, so that it does facilitate their organization, functions, policies, decisions, and procedures. So isn't this more of a fine line?
I completely concede or understand where you're coming from, Your Honor. There actually, the special master spoke to this when he found that, and again, this was not a factual dispute, that there really was no invitation to engage. There was no, there wasn't seeking of like community input into what goes into the newsletter or anything like that. And
So that doesn't have anything on it that says contact us, or?
Sure. So I think that there's like the phone numbers on there. I've actually never received a copy. I don't live in the township and haven't signed up. But I just think that the Court of Claims considered that and discussed it. The example they gave, perhaps a little extreme, was if you're driving down the interstate or down 275 and the township has a billboard, right, that says, we're having our fireworks display on, August 15th or whatever. Please come, right? So they're inviting them into something.
Right.
We wouldn't have a list of all the people that did that or that viewed that billboard. I think maybe perhaps a less extreme example might be, so let's say, for example, we post this newsletter in the Township Administration Building, just on the bulletin board, right? People could come in to see that all they want. We're not getting a list of who those people are. We don't really care who they are, but it's an option that they can choose to opt into and come and see. So it's not, I understand where you're coming from, but I just think in this case, it wasn't even always just about township business, right? There was how to dispose of junk, new churches that have opened in the area.
Mr. Conover,
Yep.
Mr. Hicks argues that the mailing list documents who the township has decided to send the newsletter to.
Mhm.
Doesn't the mailing list do that? Doesn't it do exactly that?
Yes, right?
Okay. Well, that comes right squarely within the definition of public record. If it documents a decision or activity of the township.
Well, first I would say that there's been no evidence in the record about that, but the second thing...
About what? No evidence in the record about what?
That the township made this decision to decide who is getting this message.
Well, who else would make the decision?
Well, they made the decision to enter into the contract with the vendor, didn't they?
Sure, and that would certainly be a public record. I have no dispute that there are certainly things about the newsletter, right?
The township, you're arguing that the township would have no input into the decision of who to send the newsletter to? I mean, there's a cost involved in that. How many newsletters to produce? How much postage is going to be paid? Those types of things.
No.
I mean, I'm having a hard time buying your argument that we should treat this as though the township had no input in the decision as to who to send this newsletter to.
So, Your Honor, what I'd say to that is that I just don't think that the list itself is what documents that decision, right?
What documents that decision then? I mean, well, let's set that aside. It's one thing that would document that decision, isn't it?
But insofar that it's the final product, right? But I would say there could have been, for example, a resolution. There's been no resolution in the record that says we want a newsletter that says we're going to send it to all township addresses and allow people to sign up. There could be an email, right, or a command from the township administrator to the person that used to run this program. Those might document the activity and function of the office, but the list itself is just kind of the final byproduct of those decisions and doesn't itself document what that decision was.
So you're saying they didn't go name by name and let's send it to Bob and let's send it to Frank, and
right. So
they just decided to send it to the list that the vendor had.
That's exactly right. So I think even the decision, the contract that might say something along those lines, that we want a contract with this third-party mail company that says send it to all addresses in the township. That would be a public record. I have no doubt or question about that. But just because then this list was curated, the physical mailing list was a third party, but even the opt-in ability on the email, that's just the final product of a decision. It doesn't mean that it's the documenting the newsletter and the mailing out the newsletter itself. The postage bill might be a public record. So these things, there's certainly a lot of items around that. And I think if you look at the McCleary case from the Supreme Court, that it gets to this. So
that's a swimming pool? That's
the swimming pool, Your Honor. So I have, sure, that the cost of the chemicals, the cost of lifeguards, nearly everything about the pool itself is a public record. There's no dispute, I don't think. I wouldn't dispute that. But the fact of the users, the township provides this service, things about the service are a public record, but the users themselves aren't. And you know, in Mr. Hicks's brief, he raises, and even today, it's the whole personal information. None of the cases from the Supreme Court talk about these being non-records because of the personal information. And it really gets to, how does the township use it? Oh, this is who was swimming in the pool on Saturday, July 15th. This is who received the newsletter. It's really just, again, it doesn't get to the decisions of the township. It doesn't document the decisions of the township.
Does the township even possess the list, or is it in the vendor's?
So the third-party vendor possesses all of that. And to your point, Presiding Judge Powell, the question you presented to Mr. Hicks of is mine being proprietary information. We did not. This is not, I don't think, in the record, but you know, typically,
If it wasn't raised, then it's not raised.
Right, but I would just say on a public records case like this, I've handled thousands of public records requests. If there is certain proprietary information, we would typically reach out and give the company, right, an opportunity to say, yeah, we believe this is proprietary, a trade secret, and we'd like you to withhold it. And we would do our own analysis of their decision, and I've been on both sides of this, both on the private and public side. But that never got there in this case. Because again, we just, in our opinion, is it being used by the township to do something? And this is just kind of, I don't want to say ministerial, but it's just one of those things that it's like the administrative convenience of being able to send it out so we know who to send it to. I think but some of the Supreme Court cases in the Court of Claims, and I think Mr. Hicks mentioned this in his time, there are times when addresses might be a public record. So for example, there was the public utility users case where the list and names and addresses of those using the public utility was a public record. There's the Brown v. Cleveland case from the Court of Claims where, like a sign-in sheet, you had to put in your address to speak at a school board meeting, or in that case, a city council, and that's because you have to live in the jurisdiction to participate. Here, there isn't that same sort of, there was no resolution that said, yes, township, we're only going to send it to township residents, or to sign up on the email system, you can only do it if you're a township resident. There's no verification or anything like that. And I think the record before the court from the Court of Claims is quite clear about that. There's also in the dispatch case, which is I think from '05, and sure, in that case was about public employees' addresses, but might be the most cited public records case from the Supreme Court, because it's used all of the time for these principles. But in paragraph 39, it said, you know, like for example, if you're required to live there to work, then your public employee address might be a public record because you have to live within the county to work. Elected officials, your guys' addresses are public records because you have to live within the jurisdiction to be able to serve. And so I think the sheriff there's an exception for typically peace officers to not live with it, or is exempted their public information.
Well, the bottom line is there's nothing special about addresses. They don't enjoy any special protected status.
And Mr. Hicks has raised a couple of times that there's no exemption for this. But that's because we don't even get to the exemption analysis under the Public Records Act. It doesn't even meet the definition of a record in the first place. So typically we would say, okay, let's gather all these public records. Yes, it documents the activity and function of the office. It's created or received by us, and it's a piece of paper or a tangible item. So it meets the definition of a public record under 149.011G. But here we don't even get to that. And so we're not looking for a social security number in these. We're not looking for attorney-client privilege or a trade secret, anything like that.
So why not give him the list?
I'm sorry?
So why not give him the list?
Because it doesn't document the activity and function of the office. I will say that this was a policy decision, right? So Mr. Hicks, I think, has not testified, I'm not in hearing, but presented in his brief below that he's gotten these lists from other townships and other political subdivisions. That was a policy choice by them. To be frank, Your Honor, I think the township trustees don't want to be exposing people's personal information, email addresses and addresses, and they feel strongly about protecting it. And because the law doesn't require it, they didn't release it. Obviously, if the law had required it, we would have released it. But it's
there's nothing particularly private about it, though. You can drive down the street and see the addresses, and as Mr. Hicks pointed out, the mailing list doesn't have people's names.
Respectfully, though, that's not.
I assume that the county engineer has a list. I think the county engineer assigns addresses.
Yeah, and the county,
Yeah, the county
and property records would have completely dispute that these items might be public somewhere else, but in the township's possession, they're not. So the county engineer, it's a public record, right? Because they're assigning addresses. The county auditor, they're a public record because it's assigning a property value. The township doesn't have those same responsibilities for each of the addresses, and therefore it's not. Maybe there was a request for all the ditches that were dug in front of houses in 2022, and we have, the Public Works Department might have a list of where those ditches were dug. That would be a public record, right? Because the township was doing something at those addresses where it was digging up a ditch or putting in a culvert or whatever the case may be. But in this instance, for this list that exists, it's not a public record because the township's not doing anything with it. It's just sending out a newsletter. And it's not the same as digging a ditch or putting in a culvert or paving a road or anything like that. But responding to a service call, when a fire has those initial run reports, those would have an address on it. We're not redacting those because it's not where the police were running to an emergency or something like that.
What about the suggestion that you might be sending to one political party or another, or sorting the list out? And
Sure.
limiting?
Sure. So the two responses to that. First, because we're kind of in this public access mandamus world, I don't really think First Amendment constitutionalism is not appropriate for mandamus action. So while I appreciate the reasoning behind his argument, I don't think that really applies to this. But the second, I guess, more practical part, if I can finish, Your Honor.
Yes, please.
The second part is that sorry, your question, I just went blank from the speaker.
Well, he's suggesting that you're selecting who you send it
Sure.
to by calling the list and
Sure.
sending only to Democrats or only to Republicans. Or
If that's the case, then he could have put evidence that put that into the record. It's his burden to show by clear and convincing evidence.
It doesn't matter, though, does it? He doesn't have to justify why he wants a public record.
No, but his intent also doesn't matter for purposes of of the request here today. So he
Well,
can.
I'm just saying that Mr. Hicks doesn't have to specify a purpose why he wants a record that's a public record. If it's a public record, he's entitled to it.
Yeah,
Period.
absolutely. And we didn't dispute that. We didn't ask for the intent or anything. I would never advise a client to do that because it doesn't matter. You're absolutely right, Judge Powell.
so you're saying it's not a public record, one, because you don't have it; second, because it doesn't serve the functions of this particular office, the township.
Yeah, it doesn't document the activity and function of this office, just like the Special Master Court of Claims said.
All right.
Thank you.
Unless there are further questions?
No.
Thank you. Mr. Hicks, still have 4 minutes.
I think one of the things the township's trying to do here is protect inspecting of who actually gets these things. And so that's why I think this is such an important case. It's not, dispatch case is a narrow case relating to employee records. This is about who's getting government-approved messages through curated distribution lists. I think it is a public record. Now, I'll use the 3 arguments that were in there. I think it has to be tangible, it has to be created, received, or under the jurisdiction of the government agency, and it has to document, one of the things is their operations or other activities. Who they're sending their government-curated approved messages to is a government activity. And I have the newsletter here, which, by the way, does have a contact us on it, right on the bottom. Me being able to know who's actually getting this, does everybody get it, not get it, is really important to being able to monitor the performance of government. They've claimed in their own affidavit that they send it to everybody. The person who ran the program said they only sent it to residents, not businesses, but I apologize if I have that reversed between those affidavits. What documents the decision of the township? Well, they hired a person to run the newsletter program. They hired a vendor. They did performance reviews on the person. But I want to correct something that's been presented falsely in the record. The vendor that they hired was purely a printer, not a direct mail house. So the township person who ran the newsletter, the printer, and the post office worked together to build a list, okay, and went back and forth on that list. They all 3 were involved. I think you'll find out if you look at the affidavit as well.
So that's really not part of the township's records. That's the vendor and the post office records.
Well, the list is actually their list. The vendor has it. The person
Right.
involved with the township's
But the
looking.
vendor created it and by discussing it with the local post office.
They created it by having the post office help them with providing them information from which they could build a list working together with the township. But I think I would make the point that if the government can't simply outsource something, I'm not prepared to hit on other case law.
No, but what you're entitled to,
Third-party vendor and then say it's not a public record because we never saw it.
what you're entitled to would be any correspondence between the governmental body and this vendor, which would then indicate what type of policies are being decided by the governing body.
Okay. One of the examples that he gave that I want to hit on is the billboard example that was in the special master decision, because I think it's priceless. If the government put its newsletter on billboards down the road, I would know that who sees those billboards is who drives on that road. But the reality here is that I can't tell who's getting this. Am I going to go door to door and knock? Did you get one of these? Did you get one of these? Did you get one of these? I can't tell that. If the citizen wanted to counteract a message that was on a series of billboards, they could buy a billboard on the same road to do that. So I think that this case is very different, and I think that particular example of a billboard is a completely absurd thing that was in the special master's report as it relates to this particular case. So I think that most all the cases that are cited within this case are ones where it's also brought up that if the request relates to what's defined as a public record and what is for monitoring the performance and activities of government, it's a public record. Remember the broad interpretation of the Act, to be in favor of public records disclosure. So I think that this one is, again, a really important case where right now there's really no cases that are particularly germane to this example when we're in a world now where the government can curate and target where its messages go. And what's the implication when citizens can't tell which citizens are receiving which messages from government? So I thank you.
All right. Unless there are further questions for Mr. Hicks?
No.
Gentlemen, thank you both. As I said earlier, this is our first case from the Court of Claims, and so it's one of great interest for us. We thank the two of you for your arguments today. I assume the two of you see each other frequently? Do you, on other sides?
Talking more in the lobby than we've ever done.
Oh, okay. Well, I thought maybe you bumped into each other constantly up at the Court of Claims. So,
No, I don't think so. This is our first Court of Claims case together, right?
Yeah,
Not the first, it's the
yeah,
township.
yeah.
Okay.
This is my first against the township.
all right. Well, with that, since you're the last case, you don't have to wipe. The staff will take care of that, and we will take this matter under advice, render an opinion accordingly, and you'll be so advised when it comes out. If there's nothing further, bailiff, you may adjourn us.
All right, please, 12th District Court of Appeals, the City of Ohio is now adjourned.
Thank you, Your Honors.
Thank you.
Thank you.
Have a good trip. All right. I got my morals before I came in last minute.